Alex here with part 14 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I'll glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. My ex's parental rights have been terminated. My case cannot be reopened. Number two, the purpose of the series is to provide my viewers with one big gigantic example in chronological order from beginning to end of my 8-year-long high conflict child custody case. This video is not going to really be that detailed, and as much as I don't like to do videos like that, I did promise my viewers that the purpose of the series, which was to cover my entire case, would include my entire case. This video does go over an order that is entered by the domestic master in the protective order action, but it's extremely brief and it's quite to the point. Here we have the domestic master's order entered in the protective order action. As mentioned earlier in this video, we're not going to have a whole lot to go through. It's a very short 2-page order, and at the very least, I can direct my viewers to some of the papers that led up to this order. Number 1, take a look at part 11 of the My Docket series if you'd like to take a look at the motion to set holiday visitation that my ex's attorney filed. I also go into detailed analysis on what I feel is inappropriateness of my ex's attorney's filing of that motion in this specific action. I mention in a nutshell that I believe she did so to game the system, namely to get a quicker response or possibly to get a more favorable response. I'm not going to go into those details again, but the gist of it was that we have a child custody action opened and that her motion should have been filed in that action, not in the protective order action. Part 13 of the My Docket series, which is number 2, I wanted to mention 2 things. Part 13 of the My Docket series is where I respond to my ex's attorney's motion, and I go into analysis on my approach as to how I go about defeating one of her 2 claims. So, scrolling down, in the first paragraph, this domestic master references the motion that she is going to, I guess you could say, respond to, more so that she's going to dispose of. And curiously, it doesn't mention the response that I filed, but it doesn't, I mean, usually that's what you'll see in the first paragraph, but it doesn't have to, because we can infer from the second, third, and fourth paragraphs that she definitely did review my response. In the second paragraph, she mentions that my ex's attorney's motion is granted in part. The portion that she grants is the portion that I conceded to or stipulated to. I filed my response. Again, you could watch part 13 to go through those details. And this specific period of time that my ex wanted to take the child out of state is the specific portion that I stipulated to. I had nothing really going on during that period of time, and I was quite content to take the alternate visitation that my ex's attorney proposed. The next paragraph is where the domestic master agrees with me. The Christmas visitation issue must be addressed in the custody case management hearing on December 12th. So I filed a response opposing this specific window of time that my ex was requesting on the basis that it should be brought before the child custody action, the district judge who was presiding over that case, not the domestic master, and the domestic master agreed with me and denied my ex's request there. The next paragraph just lets both of us know, both my ex and I know, that the order of protection is still in effect until it expires, or until further order of this court. Let's take a scroll down here. And we have the certificate of mailing. I've gone through several of these before. It's just a certificate that lets the court know the document was served upon, specifically which parties the document was served upon, and specifically at which addresses. And nothing really jumps out at me here. It's pretty standard. So let's move on to the next document. This is the motion worksheet. I've gone over these at least twice before, and it's just, it appears to me to be a piece of paper that some member of the court staff fills out, and really nothing jumps out as important. Probably one of those pieces of paper that they mark boxes on and fill in blanks when motions are filed in the department. I don't see these in any other departments. This is the only department that has the domestic master department. DM is the only department that has these. And there's something here. Applicant's motion to travel with the child to California. As it appears from the pleadings, that the adverse party does not object. It doesn't specifically say it's granted in that handwriting, but I'm assuming that's, I mean, they obviously drew that conclusion because that's what they put in the order. And then it says the Christmas visitation must be addressed in the custody case. So, okay, what I'm thinking is that this little worksheet here is prepared by the domestic master and given to a member of staff to prepare her order for her. So I got a little bit backwards. It's like the domestic master reviews the documents, fills out this sheet of paper, and hands it to somebody who then in turn types up her order, and then she goes ahead and signs it. So nothing really different from any of the other motion worksheets that I've seen. And this is going to be the last document, and this is the notice of entry of order. I'm not sure that I've talked about one of these in detail yet. This was entered by my ex's attorney, and it is a piece of paper that notifies me that an order was filed in this case, which we just went over. And it has a certificate of mailing showing the court that it was sent to my address. And the third sheet is the affirmation sheet, which I've gone over so many times I've lost count. This is a piece of paper that just tells the clerk that whoever it is that's filing this document swears that it doesn't contain the social security number of any person. Or one of these other check boxes could be marked, but I don't think I've ever seen that happen before. So there might be, oh yeah, this right here, the confidential family court information sheet is one of these. So I probably did go over this a long time ago and I just forgot, but this is like one of the times in which social security number can actually be in a paper. And here is the order that we already went through. And it looks like she just attached it to the back of it. She didn't even put like a list of exhibits. She just stapled it to the back. Now, if I tried to do this, it would have been rejected because the clerks won't accept it like that. They'll want a list of exhibits, and then they'll want the exhibit sheets as well. It doesn't include either of those. I don't know, maybe this department, a DM department, doesn't care about that, but Department 13 and 11, on countless occasions I was turned away when I didn't have the list of exhibits. I do want to mention something here. The notice of entry of order isn't just for show, and it's not just to make sure that I got a copy of the order. It actually controls the date from which the time limit starts ticking to file an appeal. In the rules of appellate procedure in Nevada, the time which a party has to file an appeal generally is 30 days. And I stress the word generally because there are exceptions. For example, in small claims actions, you have 5 days to appeal. But anyway, generally it's 30 days, and the time doesn't start when the order is entered. The time starts when you get notice of entry of that order. So filing the notice of entry of order is crucial because if you don't, somebody could conceivably appeal the decision months or even years later. And this kind of doesn't really make sense to me. In fact, it's so bizarre sounding that I think I may be wrong, but I've seen decisions come down from the Supreme Court of Nevada where that has actually happened. Somebody's filed an appeal months or years later because they didn't get the notice of entry of order. It was considered okay. And here's why I think it doesn't make a whole lot of sense. A lot of times, like in this case, the order is mailed to the parties by the court anyway. It already has a certificate of service mentioning that it was mailed to the parties. So I don't understand why an additional notice of entry of order needs to be sent on top of the order that the court sent to you. But from what I've seen, it doesn't matter. It still has to be sent. And I'm sure it's because that's how the court rules were written. I could understand if the court sent it to the wrong address, or if the court didn't even mail it. Like, say the court entered an order and it didn't even have a certificate of service at all. It was just entered without notifying anyone. That I can understand. I can understand somebody coming back and filing an appeal a year later if they had no idea an order was even entered. But there are so many situations where, in fact, I think most situations where the court enters an order and it always mails it to the parties. Sometimes it'll go to the wrong address. That is definitely something that happens, but I can't think of any occasion where the court entered an order and just didn't even mail it to anyone. There was no certificate of service or anything. So I would love for somebody in Nevada to clarify this, but from what I have seen, it's not enough for just the court to have mailed it. Somebody has to enter a notice of entry of order. So going into the aftermath, the domestic master in this case disposed of one motion. That is my ex's motion to set holiday visitation. It was granted in part and denied in part. And going into the financials, my ex would not have incurred any costs because she only filed the notice of entry of order, and that's one of those documents that can be filed for free. I didn't incur any costs because I didn't file any of the documents we went over in this video. My ex's attorney, let's say, would have charged 15 minutes probably for that notice of entry of order. I doubt she would have charged anything to review the motion worksheet. I doubt she would have even reviewed it. So let's say 0 minutes for that. For the order, I'm leaning towards 15, no, let's say 30 minutes. And that's only because she would have probably included a phone call to my ex to discuss some of the details of that order to her. So that comes to 45 minutes, and at the rate of $250 an hour, which is what we've been going through or going with throughout the entire series, that comes to $187.50 in attorney fees for my ex. I, of course, didn't have an attorney, so I incurred $0 in attorney's fees. If anyone has any questions, as with all my other videos, feel free to post them down in the comments below, and I will see you guys next time.